Very good evening to all. This is the 30th lecture in the Know Your IP lecture series launched by Osmania University's IPR-Chair, sponsored by DPIIT, Ministry of Industry and Commerce, Government of India. Today we have with us a unique personality who has immense practical knowledge, exposure, and expertise, not only in theory but also practice, and also as a judge. This is Mr. Vijay Kumar Makyam, former member, technical member, Intellectual Property Appellate Board, Government of India, Chennai. And his introduction probably is not required because he is very well known in the circles of intellectual property rights. Nonetheless, for the sake of posterity, it will be my obligation and honor to introduce Mr. Vijay Kumar Makyam. He is a postgraduate in law from Osmania University with specialization in intellectual property rights. He also possesses Master of Science in Information Technology, and he has practiced on the side of intellectual property laws for 1.5 decades. Just before the IPAB was abolished as part of the rationalization of tribunals, Mr. Vijay Kumar was the technical member at the IPAB Chennai till April 2021. And initially he got enrolled in the Bar Council of Karnataka in 2005. Thereafter, he transferred his enrollment to Telangana Bar. Then he has been Counsel-on-record in various IPR cases before different high courts in the country. And he also practiced on the original site along with another senior counsel. And he has been a guest faculty at NIMSME, that is the National Institute of Micro, Small and Medium Enterprise, Hyderabad, and NIPER, that is the National Institute of Pharmaceutical Education and Research, Hyderabad. And he has been a resource person with our law college, that is University College of Law, Osmania University, then Jawaharlal Nehru Technological University, Hyderabad, JNTU Kakinada, then Ministry of HRD, Ministry of MSME, and many other institutions of higher learning for promotion of IPRs. And he has a lot of international exposure as well. He has attended Japanese Patent Office training program for practitioners specializing in patents in 2017. He is also a registered patent and trademark agent for Indian Patent and Trademark Office, and he has filed and prosecuted number of patent and trademark applications and also oppositions before the Controller of Patents and the Registrar of Trademarks. And he has coordinated filing of patents and trademark applications in other countries, including US, European Union, Malaysia, Australia, Singapore, Sri Lanka, South Korea, almost, all the 5, top IP offices in the world. Among others, he has published an article called Unintentional Abandonment of Patent Applications, Law in India, in ENISHI No.19, August 2018. It's a news magazine published by the Japanese Patent Office. And he is also instrumental in organizing various seminars, training sessions, and even Moot Court Competitions on intellectual property rights. And today he has selected a wonderful topic, an emerging topic, that is evolving law around patenting computer-related inventions and artificial intelligence. And probably he is not going to explain only the basics, but given his experience and expertise, he would be touching upon many issues relating to CRI guidelines, the patenting of computer software to some extent, Farid Alani's case of Delhi High Court, and the subsequent developments. I don't want to stand between the enthusiastic participants who have been with us for the last 30 weeks every Saturday from 5 to 6 or 6:30 on certain occasions, and Mr. Vijay Kumar Makyam. So now over to you, Mr. Vijay.
Thank you, sir. I think it is a privilege for me to be here, and it is a great service to the nation that you are doing with this Know Your IPR series. The topic I have chosen today's session is evolving law around patenting computer-related inventions in artificial intelligence. Before I begin, I would like to have a formal disclaimer that this presentation is only for academic purpose. It is not a professional advice, and if you need any professional advice, you can contact the attorneys separately. And this presentation is also not reflecting the ideas of the organizations which I am representing. Now, in this session, I would like to talk about what are computer-related inventions, what is AI, machine learning, IoT inventions, and how IPR is connected to that. What is innovation, how it is different from invention, how we define an invention, how it is different from discovery, basic economics of intellectual property, what are its basic aims, how to safeguard your innovation through IPR, more specifically through patenting, and then artificial intelligence, software, IoT patents, and issues surrounding the same. And any other topic you will, or during the course of the session, if you have interested in any other topic, we can go on that. Now, artificial intelligence have been attaining widespread momentum in today's succeeding tech-savvy world. Wide scholarly technology is being incorporated within the same. It's solely a matter of time. These systems begin to manufacture spectacular inventions while not having the human intervention at all. Without having human intervention, this AI-based technologies go around everywhere, and they transform the world we are living in. So there are numerous places where artificial intelligence has been now today been impacting. Earlier, we had just robotics. Now, robotics plus artificial intelligence have huge potential to transform many aspects of our lives, like humanoid robots in supermarkets, schools, hospitals, retirement homes. Probably you have seen this Ex Machina movie, where it has been explained how emotions have been attached to the machines. There are a couple of Indian movies also, Android Katappa and Robo of Rajnikant, which have discussed about having inculcated artificial intelligence and emotions to the machine and how it works. Those movies have been placed a caution on the risk involved in infusing artificial intelligence and emotions to the machines. As more players are entering robotic ecosystem and innovation focus more advanced robotics, companies are increasingly turning to the tools of IP system to safeguard their inventions. So more and more companies are coming into AI systems, and more inventions are happening. So both offensive way and defensive way, how these inventions need to be protected, companies are focusing now. Patent protection can be particularly important in this field, given the capital incentive nature of the R&D. So R&D, it is not small amounts like in drug discovery. Even in AI-based inventions, there is huge amount of R&D invested, and these R&Ds need to be protected by companies. That's the reason companies are looking at IPR and how this robotics and AI-related inventions need to be protected under IPR regime. If you see the graph of patents for robotics field from 1980s, 1960s, they were very less. 1970s, slowly it is coming up. At 1980s, now there are more than 5,000 patents have been filed up to 2012. So the coexistence of protecting IP as well as open source. Robot operating system is one operating system which works on open platforms. These platforms invite third parties to use and improve existing content under open licensing arrangements. I hope you all know about Creative Commons, GNU, General Public Free software licenses. These licenses allow for rapid prototyping and experimenting, and collaborative platforms enables the users to share substantial upfront investment costs, avoid duplication of work, and then develop newer and newer products, newer and newer software and hardware products. Let us understand what is innovation and invention. Invention is a mechanical or physical aspect of technical accomplishment, whereas innovation is more package, complete package. Innovation includes not only invention. Invention is part of innovation, but also includes other organizational and social aspects of taking the invention to the market. Taking the whatever you have discovered to market and getting commercial benefit out of it is what innovation means. Now, the myth and reality. Myth, people say that innovation and invention happens only in educated people living in urban areas. However, reality is innovation does not just relate to education or urbanization. It can happen anywhere. Any person, anywhere sitting in the world can innovate and come up with new invention. Not all innovations need a workshop, brainstorming sessions, or big budgets. Maybe it is simple, like you are standing on a road and you get a great idea, and that can be worth of crores of rupees. See this: a bullock cart having a lorry on it. How soldiers are making omelets while they are traveling. We call jugaad inventions in India. There are several jugaad inventions. Sending the bricks from the top to bottom. So there is, if there is an invention that you are able to get it into the market and make commercial benefit, then it is innovation. However, not every innovation is product market fit. For example, here I have taken immersion heater. Immersion heater we all know for heating water. We put it in the bucket and do that. However, this guy has developed a immersion heater within the bucket, which has the plug which can be kept in the bathroom, and it can be used. But this wonderful invention, though it is exciting, though it is good invention, but there are no takers to it. That's the reason this has not commercial benefit. It has not been commercially benefited. So what we need is an innovation which is product market fit. The innovation which will subserve the market requirements. Now, most of the people, most of the companies want these innovations to happen, but how this innovation will happen, there is no straightforward mantra. However, there are some things which, if you adopt in your business and if you allow your employees to adopt them, you might get more and more innovations in the company. Like make it norm. It is not regular business. You need to, innovation is a continuous activity. You need to push aside your ego, reorganize frequently. Don't fear for the failures. Hire people have experience outside your business domain. If you're a regular business domain, you hire people, they'll do regular work. But if you hire outside business domain, they will come up and try to come up with a solution for the regular activity what you are doing. Abandon the crowd. Whatever crowd is going, you should not follow the crowd. You should come up with, you need to think out of the box and come up with the innovation. Let go of your ideas. You need to talk. You need to fight negativity. Ask what if I do in a different way, how it works, and then merge patience and passions and outsmart your customer. What your customers need, you need to think of. After 10 years, what your customers need, you need to think now. So that way you can promote the innovation. Now, in a nutshell, what is intellectual property? I think the last 29 series of Know Your IP, you know all this, but then for those people who wanted to know in a nutshell, one slide, what legal right, for what it is protected, how it is accorded, I have put it in this slide. Patents for new inventions, only on an application and filing a request for examination. On examination, the examiner will examine it, whether it will qualify to give a right or not, and then it will give. Copyright, original, creative, and artistic form of expressions. It exists automatically. You need not register the copyright. Trademark, distinctive identification of product or services. You can, when you use it, you get the protection, and or you can file a registration and get the protection. Registered designs, external appearance, shape of a bottle, shape of a keychain, shape of a mouse, any shape, external shape that can be protected under registered designs. Only on registration you get it. Trade secrets, valuable information not known to public, and you have taken reasonable steps to keep it secret, are all protected under trade secrets. This is in nutshell entire IPR. However, one single product can have multiple IP rights. Like if on the slide you're seeing the Coca-Cola tin, the brand Coca-Cola as a logo, the ring pull can technology as a patent, the formula of recipe, the drink itself is a trade secret, then the artistic image of the logo or the shape of the bottle can be kept as a copyright, and the shape of the bottle, external shape of the bottle and design can be a design right. So one single product will have multiple rights. So integrated protection, you need to protect it to get wider protection, to get maximum protection. You need to explore all of these IP rights and get it like you need to register all of these IP rights to get wider protection to you. Now let us check. Liquid is a software developer in a company called Promax AI Services, develops a product called Gym Fix that customizes gym equipment based on the user's body vitals. Computer automated physical fitness system. The moment you go on, you want to do weights based on your body, the weights will be automatically adjusted to you. Or if you want to use treadmill, the speed will be automatically adjusted to you based on your body vitals. So that kind of software has been developed by Liquid. He documents his invention in a book and wants to publish it. Before he goes for publication, Promax AI Services wishes to protect its IP. What are the different types of IP? So is it patents? As you have gone through all this in last 29 lecture series, what are the different types of IP can be protected? Patent, copyright, designs. So all the forms which gives protection, you can take up all of them. I'll not delay the time here, but you can explore what all different types of IP, and at the end of the session, maybe you can put it in the chat box. Now, what is a patent? Patent is a legal title granting its holder the right to prevent third parties from commercially using an invention without the authorization of him. So it is a negative right. In return for this protection, the holder has to disclose the invention to the public. So while you are giving this information, this patent grant, because he is disclosing the invention to the public, that's the reason a patent has been granted to him for a limited period, that is 20 years, for a specific geographic area, that is only in a country where he finds an application. So this is a layman's language. In a legal language, I can say a patent is a right to monopolize an invention. An inventor specifies the scope of activities from which he wants to exclude others. Those are called claims, and submit it to the patent office. Patent office evaluate these claims, which is depicting an invention within the sense of patent law, whether this invention is correctly disclosed and industrially applicable, that is called formal examination. And some patent officers moreover examine whether the invention is new and non-obvious, that is substantive examination. If the patent application passes this examination hurdles, the patent office grants the applicant exclusive right to produce and market the invention for a period of 20 years. What you should not do when you're considering to file a patent application, you should not file any you should not disclose this outside before filing a patent application, because if you publish, release, make a press release, or create a poster in a conference, or you make a blog entry or something like that, that becomes the prior art to you, and patent will not be granted to the things which are already existing public. You should not sell. Most often my clients come to me and say that they have already sold the product in the market and people are receiving it very well, and people suggested him to file a patent application. That is not possible. Once you sell, it becomes the prior art and the technology already existing in public, and you can't file a patent. However, sometimes you require to disclose this in public, or you require to disclose it to people who will help you, like your professor or a person who fabricates the machine for you, or who tests the product for you. So when you're doing that, you need to get a NDA signed with him and then take a professional advice or file application before others do, as patent is first come first serve basis. Now, what are the requirements for grant of a patent? Patentable subject matter is one. Generally, there are three requirements: novelty, utility, non-obviousness. But however, it is important to understand what subjects patent will be granted and how it will be granted only on your writing a specification. So subject matter and specification are also two important requirements for grant of a patents. How this patent law and policy is designed, it is a quid pro quo system. Like I said, you need to disclose the invention, then you will get a patent grant. The requirements we have already gone through. Other requirements after grant of patent is you need to file, you need to manufacture and distribute the product without creating any scarcity of the product and all. If you create a scarcity or if you sell it for higher prices, then compulsory licenses in some domains, some countries will give compulsory license. Some countries will automatically revoke your patent. The process involved in grant of a patent is from idea conception. So the moment you get an idea, you will do a patent search, and then if required, you will file a provisional specification. If your idea is in a complete form, you draft a complete specification and file a patent application. Prototype designing and testing is not necessary for filing of the patent application. However, if you make a prototype and testing, you can include the test results and the prototype drawings and everything you can keep in the patent application. Once you file a complete specification, if you have filed a provisional, you will be given 6 months time to file complete specification. If that 6 months is not sufficient, you can 12 months time to file complete specification, and if the 12 months time is not sufficient, you can post date your application up to 6 months for filing complete specification. Once the complete specification is filed, after 18 months, a patent application will be published automatically. Otherwise, you can make a request for early publication. Every Friday in India, the patent journal gets published and your application will be published there. Once it is published, there will be pre-grant opposition. Anybody and everybody anyone can file a patent pre-grant opposition who feels that it is already existing technology. And what are the grounds on which he can oppose your patent? The same. There is the subject matter is not falling under the patent subject matter. There is the technology is already existing, or it is not novel, not non-obvious, it has no industrial application, or specification is poorly drafted, it is not conveying what message the inventor is trying to communicate. All that you can take as a grounds for pre-grant opposition. The same things will be taken as ground for examining your application by the patent examiner. And if these requirements are not meeting, you'll issue a first examination report. You need to reply or respond to the first examination report within 6 months. Once you reply, if the controller is satisfied, he'll straight away grant a patent. Otherwise, he schedules a hearing, and after hearing, you need to file written submissions within 15 days. After post which the patent controller or patent examiner will grant or refuse your patent. If it is granted, you need to file renewal fees every year, and you also require to file working of patent, how many products you manufactured, how many licenses you have given, what is the money you made. All that information you need to file every year. And then in India, not only pre-grant opposition, but also post-grant opposition is there. Once a patent is filed, patent is granted, within 1 year, you can file a post-grant opposition. However, post-grant opposition can be filed only by interested parties. Section 2T of the Indian Patent Act defines who is interested party. The interested parties are those people who involved in manufacturing, who involved in research, or who involved in distribution of that product or technology which is been granted a patent. Even after the grant of the patent, within 20 years, at any point of time, if you feel that it is not fulfilling the requirements of grant of a patent, then you can file a revocation also. Now, I need to emphasize on one particular article of TRIPS agreement. I hope you all know about TRIPS agreement. TRIPS agreement is a WTO agreement. WTO, there had several agreements have been signed by member countries, and TRIPS is one of the agreement which defines how intellectual property laws, it provided a model law for adopting by member countries of intellectual property law. Article 27(1) says that patents shall be available for any inventions whether product or process in all field of technology, provided that they are new, involve inventive step and capable of industrial application. That is non-test, new, non-obvious, and utility, novelty, utility, and non-obvious. If these three conditions fulfilling, it can be any invention, whether it is product or process, in any field of technology. Any field of technology includes software and pharmaceuticals, everything. So Article 27.2 and 27.3 has given small exclusions to the generality under Article 27.1. Members may exclude certain subjects. Example, plants and animals. Plants and animals can be excluded. Computer programs and business methods are not expressly excluded from patentability. They are not completely excluded, but there is some exclusion provided under 27.2 and 27.3. And 29.2, an applicant should disclose the invention in a manner sufficiently clear and complete for the invention to be carried out by a person skilled in that. So the invention need to be fully disclosed is what Article 29.2 says. Definitions, no definition of terms invention and technology has been defined anywhere in the TRIPS agreement or in any national laws. The members may define the terms inventions in their national laws. No requirement to submit source code or object code for computer programming has been laid down in the TRIPS agreement. Now, software as an industry, if you IT industry as you take, so what is software? Software is set of statements or instructions to be used directly or indirectly in a computer to bring about certain result. These instructions, like you talk to me, like you talk to others, you are giving some instructions to the computer. Computer will do that that instructed work to you. These instructions are set out in a source code, which is human logical readable instructions code. On writing a source code, it converts into object code. The source code is compiled into object code, and finally you'll get a machine readable instructions, which is object code, and then you get an execution code. Now, why protection is required for software? Modern society relies more on software, easy to copy, easy to reverse engineer, and if not protected, it will be quite costlier. Which category of IPR? It may be copyrights, it may be patents, it can be trade secrets, algorithms, source code, object code, and the GUI, look and feel. All this can be protected. For software, source code as a literary work, screenshots with description of each screens as user manual or booklet can be protected as literary work again, executable code as computer program, and computer generated graphics as artistic works of it can be protected under copyrights. What copyright protects, what patent protect? Copyright protects expression of the idea, whereas patent protects idea manifesting in that expression. The symbolic features, the functional works which the technology performs will be protected under patents. Literal elements of protected under copyrights, non-literal functional products will be protected under patents. So copyright protects the expression of ideas and not idea itself. Software can be easily reverse engineered. Only screenshots and look and feel can be protected than the idea. Protection occurred only for reproduction of original software. So it is required. Patent protects ideas manifested in form of product or process. That's the reason we require patents for software. Now let us examine the US law. Title 35, which is US patent legislation, federal circulations, and manual of patent examiners practices. These are the things which govern, which examiners look in while granting a patent to you for any kind of inventions. So what is Title 35? Section 101 of US Title 35 says that whoever invents or discovers any new useful process, machine, manufacture, or composition of matter, or any new useful improvements thereof may obtain a patent, therefore, subject to the conditions and requirements of this title. So this is the section which says that what subjects can be patented in USA. In 1980, Diamond versus Chakravarti case, the court said that anything under the sun that is made by man is patentable. Based on this, it opened the doors for various kind of technologies, including biotechnology, including software and everything. So the categories are, it can be process, it can be machine, manufacture, composition of matter, or improvements thereof. These 5 categories are narrated in section 101. However, there are some judicial exclusions, abstract ideas, physical phenomenal, laws of nature, mathematical algorithm. These are all not patentable as per judicially created exclusions. Now, why is software patentable? Is software patentable is a question. Like programming is similar to writing symphonies. Like you write poems, you write program. When a programmer writes software, he weaves together thousands of ideas, algorithms, or calculation rules into a copyrighted work. Usually, some of the ideas in the programmer's work will be the new and non-obvious according to the standards of patent system. When many such ideas are patented, it becomes impossible to write software without infringing on patent. So, if you go on patenting software, it is impossible to create a new code. Software authors are in effect deprived of their copyright assets and live under permanent threat of blackmail by holders of large patent portfolio. As a result, less software is intent and fewer ideas will appear. Why we are talking about software patentability? Because mental processes, ideas, and mathematical formulas are not technological. Because they are not technological, writing program code is a mental process and mathematical procedure. Only the use of program has some technical result, not program itself. The computer program remains the same when being programmed, therefore it is not considered new. So essential aspect is the core software technology in the execution of a complex logics. The execution of complex logic is for most part of the skill exclusive to human beings. In the patent world, this kind of technology is called mental steps, and for long period of time was not considered patentable. In US software, 1960s to 70s, no protection has been accorded using a calculation made by a computer. 1980s, some computerized inventions are patentable. 1990s, almost every software is patentable. And from 2000 onwards, the courts pulling back only software tied to a particular machine or apparatus or software that transforms a particular article into a different state of thing. Those will be protected. Now let us examine how this law evolved. 1968, USPTO issued guidelines for computer-related inventions. These guidelines stated that computer program, whether claimed as an apparatus or a process, was unpatentable. Under these guidelines, an invention related to computer program could be patentable only if the computer were combined with other non-obvious element to produce physical results. So these guidelines obviously challenged by the patent applicants. The first case was Gottschalk versus Benson. Method of converting binary coded decimal numerals into pure binary numerals is the invention. Claims rejected by the Patent Office, sustained by the Customs and Patent Appeal CCPA. The Supreme Court reversed the decision of CCPA and said that it is not patentable. Reason for rejecting: the court felt that patent on this concept preempt the mathematical algorithm principle that has been established for a long time. Since mathematics could be considered as an abstract idea and abstract ideas are not patentable, the Supreme Court held that the algorithm in question is not patentable. Did not have any substantial practical application is what the Supreme Court said. Then Parker versus Fluke, an invention involving a method for updating alarming limits. Patent Office rejected, CCPA also rejected. Supreme Court held the invention to be non-statutory subject matter under Section 101 of the Patent Act. And the reason was the invention just identified post-solution application of the formula, and as the only novel feature of the invention was the mathematical formula or algorithm. So because the invention is based on mathematical formula or algorithm, it has not been granted. Then Diamond versus Deere in 1981. This is after Diamond versus Chakrabarty case in 1980. 1981, Diamond versus Deere. Invention related to dispute over the patentability of a process for molding raw uncured synthetic rubber into cured possession product. Invention involved the process of constantly measuring the temperature inside the mold and feeding the temperature measurements into the computer that repeatedly recalculate the cure time, and by using a mathematical equation called Arrhenius equation. This is the equation which is the crux of the invention, and then signals the device to open the press at a proper time. Otherwise, earlier people used to open it frequently and see whether it is cured or not. But this, applying this principle, it made easy for them. Patent Office rejected, saying that it is nothing but a mathematical equation along with conventional industrial methods. However, Supreme Court disagreed with Patent Office and held the invention patentable. The court held that a process would not become non-patentable subject matter simply because it employs a mathematical formula. Computer programs are digital computer as long as it produces a useful result. Then it can be patentable is what the court said. Patent is granted in USA for invention of some practical method or means of producing a beneficial result or effect, and not the result or effect itself. So what it said is, earlier it is substantial practical application, now it is useful result test. Though organized equation is not patentable, the court opined that the process of curing rubber, which incorporates in more efficient solution of equation, is patentable. And thereafter, there are several cases, Freeman, Walter, Albee cases. The court determined whether there is mathematical algorithm recited directly or indirectly in the claimed invention. If yes, the court checked whether the claimed invention is direct to the mathematical algorithm that is applied or limited by physical elements or process steps. If algorithm were applied one or more steps of an otherwise patentable process or one or more elements of patentable product, the claimed invention will be patented. So thereby the patents have been granted in these three cases. Then in re Alpat, invention relates to a means for creating a smooth waveform of display of digital oscilloscope. Patent Office rejected. Court disagreed with the Patent Office, held that the invention to be machine, which falls under the scope of statutory subject matter. Then the test for patentability of computer program was not clear. The court made an attempt to make lucidity by clearing it, interpreting the Diamond vs. GR useful result into a more clear test, that is concrete, useful and tangible result test has been propounded by the court. Then in re Lowry, patentability of a memory containing a data structure has been filed a patent application. Patent Office rejected. Appeals Board determined these claims were statutory, but then the printed matter exception has been taken to deny the patent. Federal Court reversed the decision, holding that the printed matter exception applies only to the printed line and character, useful and intelligible only to human mind. Data structures are not processed by human mind, but a machine. The printed matter exception does not apply there, and they refuse the patent grant. In State Street Bank versus Signature Financial Group in 1998 is a major decision towards the software patenting. Invention related to data processing system for implementing an investment structure, which was developed for use in business as an administrator and accounting agent for mutual funds. State Street Bank initially tried to get a license from the Signature Financial Group. However, negotiations failed, and when State Street Bank then claimed patent invalidity as it is mere computer program, District Court held patent not valid. However, Federal Circuit reversed the patent invalidity decision of District Court. It held that the process patent should not be held invalid merely on the ground it involves mathematical algorithm. As long as it produces concrete, useful and tangible result, the patents will be granted, is what the Federal Circuit Court said. Thus, it opened the doors for the software patents. Thereafter, in re Komsky and in re Bilski, and then in re Bilski, interesting thing is machine or transformation test has been propounded. A claim process is patent eligible if it is tied, if the software is tied to a particular machine or apparatus, or if the software performs a particular article into a different state or thing. If you feed a paper, you get a machine. If you get a toy kind of a thing, then it is transforming the state of article into a different thing. That kind of test has been evolved. Machine or transformation test is the sole test for determining patent eligibility instead of a useful and important clue as an investigation tool. So in re Bilski, this important test has been developed. Thereafter, Alice versus CLS Bank also been upheld the test of Bilski. Are the claims directed to patent ineligible concept? Is there any inventive concept in the claim? That is an element or combination of elements that in practice amounts to significantly more than a patent upon ineligible concept itself, then patent will be granted. So from Gottschalk versus Benson to Alice versus CLS Bank, there is a series of judgments which evolved the software patenting in USA. There are almost in 1985 less than 2,000 patents to more than 16,000 patents have been granted in USA for software patents. One of the major patent, that is one click of Amazon.com, which has been settled with undisclosed term, but the suit has been filed and they settled out of court. Then Bleesburg Technologies single spreadsheet basket of trades. March 2000, it entered deal with Instinet and got 14.3 million initial offering in April 2002. Larva Trading, one screen consolidated trading on multiple ECNs, patent issued in 2001. They got 30 million funding, which is led by TA Associates. So what software patents are good? Software, if you take Google, Google is built on few key software patents, and the value of Google is, it was old value 123 billion. I think it is more than that now. Then there are several technologies, domains where software can be used, compression technology, language translations, financial software, security software, voting software, communications and interoperabilities. There are so many other fields of technology. The case of patents in software industry is not different from the theory of other patents in other industries. Software patents can help small innovative firms. There are a lot of problems with current patent law, and some of those problems are especially affecting software industry. So to give a recap of what happened in US from Gottschalk versus Benson till Bilski, initially Gottschalk versus Benson's patents are not granted. Parker versus Fluke, only claim of practical application. Then Diamond versus Deere, useful result. INRE Alpert, useful, concrete and tangible result. Then State Street Bank case reiterated the concrete, useful and tangible result. INRE Bilski tried to particular machine or transform the state. Now coming to AI, artificial intelligence, with machine learning, deep learning are some of the concept of the AI. AI and its application, there are e-commerce, healthcare, retail sector, manufacturing, self-driving cars, marketing. There are several other applications of AI. AI means an ability of machines to perform tasks normally attributable to human beings or animals. The ability to perceive, reason, plan, act, and learn is called artificial intelligence. Now, AI is disrupting every major industry. We are already seeing AI makes its impact on our daily lives, both in visible and invisible ways. And the possibilities of this class of technologies is almost limitless. Artificial intelligence and AI is subject matter of various patents based on inventions in the field of machine learning, data analytics, natural language processing, natural language search. AI is used to automate existing resources, including human resources and data, to generate return on investment for enterprises. So patents were designed to motivate. Now the issues are, patents were designed to motivate an inventor. Is such motivation still needed if AI is an inventor? If computer becomes an inventor, do we require to grant patents to motivate the computer? If an AI invents something, is it patentable? If so, who owns that patent? Is it the machine? Is the person who created this machine? How do we enable a claim if we do not know how AI made it? Now, if AI has made a machine, how that can be reconstructed? Only that machine can make that second machine, right? So how this need to be tackled? If AI can be inventor, can it also be an infringer? If you grant a patent to AI, can you also punish machines for infringing third-party patents? What remedies are appropriate? Are the aspects of AI that should be accessible to all? What risks exist if someone can control the AI technologies? Is AI patentable, or is just an algorithm that is law of nature? Recently, South African Patent Office granted a patent to Dobhouse, an AI as inventor. In similar lines, Australian court also ruled for grant of a patent to AI as inventor. Even in India, somebody I think filed Raghav as a copyright applicant. However, that has been refused, and then some individual's name has been kept along with Raghav that has been registered as a copyright. Can AI original works be copyrighted? If it is software written by humans, should they receive should the AIs receive copyright protection? Is an AI like an animal The US court has held that no one owns a monkey selfie. Like you might have known that there is a issue happened with monkey selfie photograph. Who is the author of inputted data, trained model? Is there any sufficient originality? Is originality has a low bar? What is the authors? Who is the author of outputted data? All these are the questions that need to be answered to grant IPR protection. There is one interesting video. I have shared the link on the top of my screen. Automated content creation. This is a software application that is patented by Philip M. Parker, US patent number 7226767, which is filed in 2000, issued on September 4, 2007. So this patent says that software will create the content on its own. If you want a lecture on artificial intelligence or IPR, the software, you just require to key in what you want, and it will dig out, it will dig in the internet and create content on its own. Like a PhD scholar does research, the software does the research on its own and gives the result. So whether that result can be protected to this software, or it need to be protected to Philip M. Parker, that is a question we need to answer. The patent is automated content creation. Maybe you can go to the specification and all. There are so many companies which are filing artificial intelligence patent applications worldwide, starting with IBM, Microsoft, Toshiba, Samsung, NEC, Hitachi, Panasonic, Canon, Siemens, Sony, Toyota, LG, Bosch, Sharp, HP, Intel, Baidu, Nokia, Philips. There are several companies which are working on AI related patents. Now, with regard to monkey selfie copyright dispute, monkey selfie, whether it is copyrightable by monkey or human, Naruto versus David Slater case happened in US in 9th Circuit Court. The court held that monkey is not an author within the meaning of US Copyright Act. Further, the court also said that even if Naruto had taken the pictures by independent autonomous action, the suit could not constitute, as animals do not have any standing before the court of law. Even assuming that it has a copyright, it can't file a suit because animals will not have any right. After the case was dismissed by the California, PETA filed appeal before US Court of Appeals for the 9th Circuit, and the decision of US Court of Appeals for the 9th Circuit, the US Court of Appeal for 9th Circuit, while referring to the issue, said that in the present case complaint, PETA alleges that Naruto is the author and owner of the monkey selfie. The complaint further alleges that Naruto has suffered concrete and picturized economic harms as a result of the infringing content by the appellees. Harms that can be redressed by judgment declaring Naruto as the author and owner of monkey selfie. Further referring to Katakan community case, the court said that Katakan crafted a simple rule of statutory interpretation. If an act of Congress plainly states that animals have statutory standing, then animals have statutory standing. If the statute does not plainly state, then animals do not have statutory standing. The Copyright Act does not expressly authorize animals to file copyright infringement suit under statute. Therefore, based on the court's precedent and Katakan, Naruto lacks statutory standing to sue under the Copyright Act. So the court said that it is, though, first of all, it can't own rights, and even if it is assuming own rights, it doesn't have a right to file a suit, is what a court categorically explained in this case. As I said, recently, Indian Copyright Registry has granted a copyright registration for Raghav as an author. However, initially the registry, in the registry, when applied Raghav as a sole author and owner of the copyright, it refused. However, an application by individual along with a app, that is Raghav, has registered the copyright. Europe has similar law. Software Copyright Directive 91/250 EEC requires copyright law to recognize software as a literary work. However, US EPO's Article 52, patents shall be granted for any inventions which are susceptible of industrial application, which are new and which involves inventive step. However, there are certain exclusions. Discoveries, scientific theories, mathematical methods, aesthetic creations, schemes, rules, methods of performing mental acts, playing games, or doing business, and programs for computers are specifically excluded from granting patents. Presentation of information. However, these things are stated to exclude only to the extent they relates to that thing as such. Independently, if you claim as such, then it will be excluded. Otherwise, if it is attached to some other things, then it can be patentable. Strict reading of the law leads one to believe software as such is not patentable. However, EPO Board of Appeals interpreted as such very broadly in several cases. 20,000 software patents have been approved. More than 6,000 applications per year are filed only in UK. So software is patentable in Europe. What they say is technical character. EPC limit grant to patents to inventions in all fields of technology rather than just to inventions. Patentability requirement of novelty, inventive step, and industrial application are defined more detail in EPC and national laws. However, there is no legal definition for the term invention. EPC restricted patents to technical inventions. Inventions having a technical character as far as the EPO is concerned, which are or may be implemented by computer programs, are may be patentable. Now, what is technical is not defined, and the court have found it very difficult, if not impossible, to come up with a working suggestion as to what technical means. What is technical to me might not be technical to you. Softwares will be patentable in Europe if it is technical, makes a technical contribution in the field, not excluding from in a field and not excluding from patentability, is a solution to a problem involving technical consideration, produces a technical effect going beyond the normal interaction of the computer and the program, or just generally has a technical character, then it can be patentable. There are several cases like Littleman test, which has been proponent in CFPHL LLC application, and Vicom in 1986. Then PBS partnership case, Comvic. Then most recently in 2006, Aerotel versus Teleco, Symbian. So those are the several cases in which the interpretation of per se, computer programs per se, has been done by EPO. Indian patent law on software patents, Indian Patent Act 1970, algorithms and software were excluded. In 1999, amendment came and they said, like in Europe, as such, software per se in India has been excluded. In 2005, amendment in the ordinance in the form of a computer program per se other than its technical application. So they have added technical application to industry or combination with hardware is been added in 2005 amendment. The Act right to strike balance between the rights of the patent holders and its obligations to society that grants in the patent. So the basic philosophy of the Patent Act has been laid down in section 83, is that the patents are granted to encourage inventions to accelerate indigenous industrial growth by securing their working in India on a commercial scale. And the patents are not granted merely to enable patentees to enjoy a monopoly for the importation of the patented article. So section 83 said that patents are granted to work in India, not for just importing. The Act excludes computer program per se under section 3K. The Act also excludes mathematical algorithms and business methods under 3KA. Then there is a draft manual of patent examination. Further to it, guidelines on examination of computer-related inventions in India has been made in 2013. Post which some modification has been made in 2016 to the said guidelines, provided illustrative examples of non-patentable computer implemented inventions. And then they have made revised guidelines for examination of computer-related invention in 2017. The draft manual said that under this provision of section 3K, mathematical methods, business methods, computer program per se, and algorithms are not considered as patentable inventions. In relation to computer programs, the law provides a qualification that what is not patentable is only a computer program per se. Claims directed at computer program products are computer program per se stored in a computer readable medium and as such are not available. As such, the computer program as such are not available. If a claim in a patent application is not directed to a computer program per se, it could be patentable if all other patentable conditions are met. This provision thus necessitates distinguishing computer program per se from other types of inventions that implements or uses computer programs. Computer programs are often claimed in the form of algorithms or as method claims and system claims with some means indicating that the function or the flow chart or process steps. The algorithm related claims may be even wider than the computer program claim by itself. For a program represents a particular set, the algorithm expresses the principle generally and gives way different way for different programs to be written based on the same algorithm, and as such are not, the algorithm as such are not patentable. So this has been narrated in the draft manual. So in the guidelines, what they said is whether the claims directed to computer program or not need to be checked. If claims are directed at computer programs, set of instructions, routines, and subroutines written in a specific language, or claims directed at a computer program, product, storage medium, database, computer memory, computer program per se stored in a computer readable medium, or claim is directed towards simply using a computer to automate what was previously done manually. Examples like what is already existing, that industrial process you are doing through computer, automating it. Claims directed to means plus functions where no structured features of those means are disclosed in the specification. Further, if the specification is supported, specification supports the implementation of these inventions solely by software, then the case means the in the means plus function claims are nothing but software, and it need to be excluded from patenting. Then tests indicators to determine patentability of computer related inventions has been provided in 2016. Examiners may rely on the following 3-stage test in examining computer related inventions: properly construe the claim and identify the actual combination. What is the claim? What is it is been claimed for? If the contribution lies in the mathematical method, business method, or algorithm, if the entire contribution of the invention lies in the mathematical method or business method or algorithm, then deny the claim. If the contribution lies in the field of computer program, check whether it is claimed in conjunction with novel hardware and proceed to other steps, whether it is in combination of hardware, like machine or transformation test in Bilski. Here also they are saying that whether it is computer program along with hardware, and proceed for the other steps to determine patentability with respect of the invention. The computer program in itself is never patentable. If it is if the contribution lies solely in the computer program, deny the claim. If the contribution lies both in computer program as well as hardware, then proceed for the next steps of the patentability. So there are several grant cases and 1 or 2 rejected cases. While drafting a software application, one should keep in mind the patentability criteria and section 3K of Indian Patent Act, which bars mathematical or business method or computer program per se. If you remember that and draft a specification as complete system including the hardware elements, then the case, chances of getting a patent grant are higher than merely claiming the algorithm or merely claiming the business mathematical formulas. They will not be patented. Then Farad-Alni Intellectual Property Appellate Board had a chance to make a review of the refusal of the patent application for Farad-Alni, that in computer inventions that meet criteria of technical effect are patentable under law is what IPAB said. Artificial intelligence, AI, and related technologies are all persuasive and permeating into every sector of business. As far as protection of AI is concerned, the Indian Patent Act currently provides protection only to the true and first inventor, which implies a legal person, which include either a natural person or an artificial person like a corporation, not to a machine. Section 3K of the Patent Act clearly states that mathematical or business methods, computer program per se, algorithms are excluded from patentability. In the case of Allied Friendly, IPAB states that computer invention that meets the criteria of technical effect are patentable under the law. This order opens the door for enormous corpus of inventions to now become protectable and more valuable, as patent protection of inventions in India is essential for fostering the AI inventions and software inventions. The Delhi High Court also on computer related inventions has relied on IPAB's judgment and said that across the world, patent offices have tested patent applications in the field of innovation on the fulcrum of technical effect or technical contribution. If any invention demonstrates a technical effect or technical contribution, it is patentable, even though it may be based on computer program. So if it is computer program, still it will be protected. However, it need to have a technical effect or technical contribution. The court further held that the patent applications deserve to be considered in the context of settled judicial precedents, which have now laid down the interpretation of Section 3K, the guidelines, and other materials, including legislative material. Accordingly, the court directed the Patent Office to re-examine the application, giving the applicant an opportunity of being heard and issue the decision within 2 months in Farad-Alni case. Similarly, in Australia also, on software patents, there is a lot of debate happening. One interesting thing, there is this Intel application, a device having a credential management system and a method of operating the same, which is filed in 2005, has been refused, saying that it is not technical invention and it is a mere software program. However, the same patent has been granted in USA. So it depends upon country to country and the evolving law around it. So there is a proposal for sui generis protection for software. Why not go a separate way like plant varieties? Why not software need to be separately protected? Software seem to have problems with both copyrights and patents. Why not a separate sui generis system? New right that has a shorter lifetime, like you don't require 20 years, maybe you give 5 years, but a greater protection. That is what has been sought for software. With regard to AI can't be an inventor. There are several decisions around the world saying that AI can't be an inventor. Computers can't get rights, or machines will not get rights to it. Like monkey, an animal can't get a right. How can a machine get a right is what people are asking. However, some patent officers saying that the rights will be associated to the person who created that machine, and he can enforce those rights. So like that, there are several principles are evolving in the AI field.
Thank you so much, sir, for the elaborate discussion on the different aspects of computer-related inventions and AI. Now, I request our chair, Professor, to please continue the proceedings.
Yeah. Thank you, Dr. Irfan. Thank you, Vijay. In fact, it has been really an exciting session with so many new developments being brought to the notice of participants. Maybe, after you started, about 20 minutes later, somebody said, what about the computer related inventions and AI? But after that, you never gave them any chance. And probably this much information is not available in any of the, even academic lectures, which are organized as part of the regular pedagogy. Well, thank you very much. And I mentioned to you that we started this season 1, that is Know Your IP series, on 18th December 2021. Today is exactly the 30th lecture. And during the last 30 weeks, we have had an opportunity to host many eminent IP professionals, including academicians, IP attorneys, and even the others related to the field of intellectual property. And we have had eminent resource persons hailing from IITs, including national law schools, and those practitioners who are in the field of IP for well over 1.5 or 2 years, 2 decades. And starting from the theoretical aspects, the conceptual, the understanding of property and intellectual property. Now we have come to a niche area, that is artificial intelligence and computer related inventions. It has been a delightful journey, and I'm happy to tell you that during the last 30 lectures, the number of registrants who registered from all parts of the country is 5,991 as of now. So on an average, almost 200 participants registered for each lecture. And there have been many highs, like, there were as many as 529 in one particular session, and there were also about 100 in another session, but average is that much. And I must thank all the resource persons. In fact, I started with my own lecture, but that was only a curtain raiser. I call it season 1 of Know Your IP series. And I can tell you that even in 5-star ambience, even, in those highly, in fact, technical or the seminars which are organized in 5-star hotels or convention centers, you don't come across this kind of dissemination of knowledge relating to intellectual property in theory and more in practice. And that way, we are very fortunate to have so many resource persons, starting from Ms. Sai Bhavana, Professor Dwarakanath, Dr. Venkat Reddy, Ms. S. Ravi, IP practitioner, Subhajit Saha, Gargi Chakrabarti, Dr. Arun Kadri, Dr. Vishwajit Kalyan Das, Professor Pratap Reddy, Dr. Yogesh Pai from National Law University, Delhi, Mr. Syed Afsar Ali Bukhari, Mr. Suraj Gemini, Ms. Aarti Ashok, Dr. C.P. Nandini, Professor K.D. Raju from IIT Kharagpur, Dr. Atira P.S. from New York, Kochi, Dr. Balkishna Reddy from Nalsa, Mr. Ashok Ram Kumar from Verdict IP, Professor A.V. Narasimharao from ICFI, Dr. A.S. Chakravarti, he is from the library science, he heads the OU library, Dr. Betsy Vinolia Raja Singh from, in fact, the Dr. Ambedkar National Law University. Then again, Dr. Sunanda Bharti from Delhi, Mr. M.S. Bharat, that is Kriya IP, and Dr. Divanshu Srivatsava, Ms. Srinithi, Professor Dr. T. Ramakrishna Sir, Dr. Gautam Bhattacharya, then Mr. Vijay Kumar Makyam. So, altogether 30 lectures, all of them are hosted on our, in fact, blog, IP blog, and probably it could be a very good MOOCs program. And 3 credits can be easily given, provided it is converted into those, in fact, 4-quadrant model. And I must thank all our participants. Most of them took this particular endeavor very seriously, and they have been with us, almost 30 to 40 participants. They have been with us right from the first lecture till now. And they have asked very meaningful questions and interacted with the resource persons. And it was a learning experience truly for other participants as well. We have covered number of areas, but I would call the season 1 as the macro level understanding of intellectual property rights. And probably, overstressing or overstretching oneself sometimes exhausts. Therefore, we thought that we deserve a break after so many episodes, right from 18th December 2021 till now. And we would like to give a break so that we can come back with season 2 fully, in fact, redesigned and, with the new innovations and maybe with more cutting edge areas coming up. And that we propose to do in the first week of September. And we will be in regular touch. And we thank all the resource persons, each one of them, with wholeheartedly from the bottom of our hearts. We also thank all the participants who have been with us, who encouraged us, and who also, in fact, taught us so many things. And we expect similar kind of participation, cooperation with equal enthusiasm in season 2. Sayonara from us. Thank you, Vijay. Thank you so much, because you have been with us in the national seminar, which was attended by almost 5,000 people. And now today is because it is very good that you have completed the first cycle of season 1 of Know Your IP. Now with these few observations, while thanking all the concerned, the eminent resource persons, all the participants, all the institutions, my own team consisting of Dr. Irfan Abbas, Mr. Srinivas Rao, Mr. Nagaraj, Ms. Vaishnavi, and many more. Now I will request Mr. A. Srinivas Rao, my colleague, to propose a formal vote of thanks. Over to you, Srinivas.
There was an age when oil producers were rich, but now entering into an age of technology, we are witnessing how machines are learning our language and how the deep and complex solutions can be sought from the technologies like AI, metaverse, and complex learning machines. So more you have the technology with you and embedded with it, there are more chances of making money these days. Thank you, sir, for today's discourse during season 1, week 30, on the topic evolving law around patenting computer-related inventions and artificial intelligence. This is Srinivas. It is my privilege to host the vote of thanks today. Thanks for taking up time from your busy and precious schedule and taking us through the basics of patenting, explaining of various concepts of patenting, differentiating between jugaad, that is what is not patentable, and with the contrast of what that is can be patentable. Then you explained about 101, which allows few more inventions, yet restricting few instances, such as mathematical and algorithms and complex programs, computer programs, etc. You talked about the reasons why software patents are not granted, and then migrated to AI, which is artificial intelligence. While there is a huge potential to create more work on AI, you have cited good examples that what an AI can do in future, such as creating a research document even by researching the entire the law books or any other books contents. You also cited narration of US court in case of monkey selfie copyright case. You mentioned about the granted cases and rejected cases, those applied for patenting. And finally, you mentioned about Farid Alani case in view of IPAB decision in conjunction with AI. So your lecture was also evolving, starting from the basics and taking the participants to the advanced level of decisions and the case studies. So here, on the behalf of DPIIT IPR-Chair, OU Hyderabad, India, thank you one and all for attending the season and the session and encouraging our work. I would also like to thank all the participants, all the resource persons till now, my entire team who have been working and coordinating with each other. With this note, hope to see you all once again in the next season. And now we would like to conclude this session with the consent of the chair. Thank you, sir. Thank you. Thank you, GB Reddy, sir, for your constant effort and helping us every time.
Thank you.
Thank you, sir. Thank you
you
for
all.
inviting me for this session. Thank you.
No, thank you. Pleasure.